which have to.
The affidavit sworn on 30th of June 2025 by Samuel Itegi.
Paragraph 20.
Paragraph 20. Which that we gloss over. If the second petitioner were to leave court today, there is a real danger that he may be arrested. Pray that when the court is making directions as regards the petitioner, the court consider be bonded to attend to this court when required, so that the question that
so I had to debate it in giving its direction.
That have led us
Which affidavit?
There are two affidavits. The first one was sworn on the 1st day of July 2025. And there is another one sworn on the 24th day of June this year.
So, Mr. Data, we should begin sequentially.
On to the 1st day of July. Thirdly, my lord, the DCI regards all the issues raised. My lord, fourthly.
So, I didn't get.
Wants to be had.
Today?
Today, my lord, before you. Now that you've summoned him. Wants to be had because
Yes.
they have not been treated fairly in this matter.
They say
they need an opportunity really to state the facts as they are. My lord, an application has been made orally. I am not privy to the basis of our application.
which one?
One for Mr. Kibe and Mr. Wakabata.
Yes.
Yes, and Mr. Willis Otieno. I pray that we make a formal application so that we have an opportunity to respond.
You are mixing up.
Let
me see whether we are speaking.
Correct.
Mr. Kibe made a specific request on behalf of the family that they would want time with the second petition. That's number one, and that's the primary application I had from Mr. Kibe. So what do you say to that? Not mix his and the other people.
My answer is simple.
Yes.
Mr. Kibe is not a party in this proceedings. He's not a party in this proceedings. I have no problem. In this proceedings. I will be in a position to respond to an application made by a party.
Okay.
Yes, Mr.
So you're not able to respond.
My response is Mr. Kibe is not a party in this proceedings. He cannot make an application in proceedings that he is not a party. It has not been joined. It's not a party.
Okay.
There is the application. Mr. Willis Otieno, my lord. There is a prayer that was sought for the unconditional release And prayers of habeas corpus, my lord. Look at prayer 8, my lord.
That's in the original motion.
It is in the notice of motion, my lord, the one that gave direction.
Yes.
Dated 24. That has been sought. It's only fair that we deal with this motion, my lord, before we. I believe that you're coming for directions, my lord, so you can give directions. That is my reference purpose.
My lord.
Respond.
Yes, my lord.
I want to find out where I got Mr. Peter. Well, what you say, Mr. Peter, is
Yes.
that you want the DCI to be allowed to speak.
Because you called me.
Because,
Come and
yes,
address.
yes. I'm not saying I didn't do it. Why are you here?
Yes.
That's all I want to hear.
Yes.
Because the petitioner, the family has a specific request. The petitioners, counsel for the petitioners have their way of looking at things. So I want to know whether you agree that we hear him today, despite the request from the petitioner's family.
Despite the request, my lord, because of the schedule.
So I have no problem. I just wanted to know whether that's the way you want us to proceed, so that I give directions.
Yes, my lord.
Mr. Mungai?
Yes. My lord, it is very strange. We presented to the Attorney General 156 of the Constitution, I believe, Article 6 talks about the Attorney General shall promote, protect public interest. This is the habeas corpus application, is the subject matter of the petition.
Yes.
In a habeas corpus application, and by the nature of habeas corpus, the family and invariably corpus application are instigated or instituted.
Yes.
And therefore, for purposes of this proceeding, was not there to give instructions that should be construed as the family of So the family of Ndiangui Kinyagia is already a party. It is a necessary party. In the nature of happiness purpose. Be completely unusual. I advise that you would come as an interested party. So for purposes, so will appear as an interested party. But now that he is there, and when we speak to Ndiangui, the second petition, because all of us, even out of curiosity, want to know where was he, and where has he here the day before? We want to know that also. If nothing else, for purposes of curiosity. Therefore, we need to talk to him as we had requested, but we can formalize the proceedings because we need to apply for his protection. You must oblige, my lord.
Madam, do you have a right of reply on my application?
Which one?
The question of the liberty of the individual and the need for him to be given an opportunity to get medical attention. He looks physically traumatized. I'm not a medical expert, but applying my elementary knowledge of human
So
health.
if you continue talking, he wants medical attention, what are we doing to him?
That's exactly what I was going to say, that we should not talk too much, but we should by issuing the order that allows his liberty and an opportunity to access medical help.
Where I am, I think we are losing the point. I have the DCI in court. I have the petitioner in court. The family has requested to have a conversation with the petitioner, second petitioner. I have parties who want to keep us here. We want, Mr. Bitter says they were not treated well, he will tell us. The other side wants to cross-examine the DCI. So how do we proceed? Which one should we give preference to?
Goes to hospital and we proceed.
It is something, a decision we have to make conscientiously. If the health of the second petitioner is primary, or do we keep the DCI here?
My Lord, I think we should give way to the family and parties. Those who are needed by the court can come on the next date. The application was about the well-being of the second petitioner. And I think, in all fairness, we ought to give way, even though we were rallying to go, we should hold our breaks.
Mr. Dita,
Yes, my lord.
how many deponents do I have? I have 3 affidavits from Buire. Is it mistaken?
No, my lord.
There's one called second respondent's further affidavit. That Buire. Seems to be the same.
No, my lord. The first affidavit is by Samuel King.
That I have.
Yes.
That's the original.
That's the
Yes,
original.
that one we have.
Then we have a further replying affidavit by Leonard. That one is sworn on the second day of July.
So is that one of Buire?
Yes. So there's Leonard Siele, and then there's Patrick Will.
The first one is?
The first one is by Samuel Kitig.
Yes.
That is the first one.
Yes. Yes.
The second affidavit is by Leonard Siele.
Don't have that one.
Don't have it.
The third?
The third one is by Patrick Will.
I have 3 copies by Patrick Buire.
Maybe they printed the same one. But we supply, we have copies of it.
Can I check? Let's see, online. All these things. But see, can I check?
Mr. Marwa actually uploaded it. personally.
No, you are now the lead.
Yes,
I'm told you are his senior.
yes, and I trust him.
So how do you throw it back to him? Because you are the one. I'm looking at the system.
Yes.
It is the same affidavit by Buire that was uploaded. It was uploaded twice. Someone else who can assist me, maybe we are wrong on this thing.
Your Lordship, there is a,
Yes, Chair.
I've given a physical copy right now.
No,
just in case
it has to be here. Because this is the file.
of-
Your people can upload it now. But let's see the. Have you seen the one by Sele?
Yes, yes, my lord.
The one by Sele. We don't have it.
Lord, he can re-upload it.
Yeah, what's the We are still trying to confirm. You know, the systems are sometimes slow. Yeah, it's here that you uploaded Buire twice.
Lord, I wanted to address you on a question. An issue that Mr. Peter has raised, but my senior, Mr. Kopere, and has better particulars of that. He's 38 years in the profession, my lord, and to me, that
Please, my lord. Leaving what my vice president has said, I am the second senior most after senior counsel Karua. But I just wanted to bring something into context on the four. The first one was on the summoning of the CEO of the Law Society. I appear for, together with the rest,
for 44 years.
the question of cross-examination, which can be dealt with at the appropriate time. and third applications by Mr. Bitter because they go against each other. The second application was the fourth link of Mr. Bitter's application. So those are the the four issues I wanted to bring to context. You can be able now to balance what Mr. Bitter requires, what we also require, and the fact that at a later stage,
He's read what he wants to say, and then clear the way for that. Bearing in mind, I have a specific request from the family.
yes,
So if you want us to go that way, we'll take the stand, be led for the reasons that the court directed he be here, nothing more.
I think my learned senior, my learned counsel can be able to now.
So
say
you look at the directions I issued, he was to be here for commission. We are not digressing any other issue. If we are sticking to that, that's what we are doing, Mr. Bitter.
Yes, I want, let me address you on that because I've received some instructions. He wants to respect the wishes of the family. Now that he has answered the summons of the court to appear, and the second petitioner is present, that you discharge him will start those summons have been paid.
What is he telling you, Mr. Bitter?
No, he's telling me to abandon the other applications.
it's already on record.
And all of the applications will be on record to abandon all. So as regards the DCI, my lord, is that you discharge him. Doesn't wish to oppose the wish of the family. Those summons are actually in this matter.
Senior counsel, I restrict submissions to 10 pages. How many pages would you want to have?
I think
10 will do.
would do, yes.
We are
What
dealing
one-
with the petition because there are specific issues raising.
Then make it maybe
15?
15, yeah.
Mr. Bita, would 15 be fine
More
with
than
you?
happy.
The case be disposed by both submissions and viva voce evidence, because we still have that cross-examination issue.
Yeah, so does it make sense to file submissions before?
It does not.
Doesn't?
We actually should have have the cross-examination before submission. Submissions are a wrapper.
Yes,
Yeah.
we have to change that. Want us to agree on a date we can have the hearing? This matter will be had through viva voce evidence. We don't have dates. We will try to see because of the nature of this matter. Yeah.
I think,
We already have the affidavits. We will have the affidavits.
yeah, but we are not even talking of our witness. We are talking of cross-examining DCI and the deponent.
I'm talking of your case. How will you take to present your case?
I think our one day then.
One day.
Yeah, not more than one day. Yeah. It could even be less, but to be on the safe
You
side.
know, I have affidavits already.
Yeah.
Yeah, they will come here and adopt affidavit and be cross-examined. That's the way
Although
we
we have
proceed.
requested for somebody without any affidavit, the DCI, because it is his officers who swore, yet.
We will reach there.
Okay.
Let's deal with you.
Okay.
I'm looking for your side.
Yeah.
Don't worry, because they will come and they will cross-examine. Do you agree?
3 hours for highlights, but cross-examination would be a day plus. We had prepared Varadi.
Are you suggesting there are days you come without preparing?
No, but because of the problem we are talking about, we had come loaded more than usual.
That will take so long.
Yeah.
I'm suggesting 17th and 18th of July for hearing.
May I request we push another 2 days? I have a personal problem. I'll be out I'll be returning on 16th and 17th. I'm in Kampala. So if I and Kampala, I'm lead counsel.
No, you said you are not available, so
Just by 1 day.
when are you in Kampala?
On the 17th.
17th.
Yeah.
Will you fly back? You don't
It's a
know.
day trip.
No, will you fly back the same day?
Yeah, it's a day trip. That's what I'm saying. Going in the morning, back in the evening.
So we can take 18.
Yeah.
Can take 18.
No, they welcome me. No, I'm supposed to be in there.
So we'll have to stagger it. We take 18th, and then we'll proceed on 24th. How is that?
That's okay.
Mr. Bita?
18th, that's okay.
24th. That's okay.
Some time allocation or
I will come to that. Let's just agree.
The mother is not here, so
A doctor from China showed the world how to slow down aging.
So I suggest we start 10:30 each day.
10:30. 10:30, it's okay.
That's okay? The petitioners will have 7 days to file a supplementary affidavit if need be. Have the petitioner with them and take him to hospital for medical attention. This matter will be heard on 17th and 24th of July.
18th, my lord.
18th of July. Inclusive. In the meantime, shall not arrest the second petitioner, Ndiangui Kinyagia, a petitioner in this matter, and may be required to testify. Advocates, but he should not be arrested or detained